Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. Jones, decided November 27, 2018. Memorandum. The order of the Appellate Division should be reversed and the indictment dismissed. Defendant was convicted, upon a jury verdict, of enterprise corruption as defined by Penal Law Section 460.20, the single count filed against him in the indictment. For purposes of this appeal only, we assume, without deciding, that the people established the existence of a criminal enterprise. Viewing the evidence in the light most favorable to the people, as we must, People v. Condis, the proof elicited at trial was not legally sufficient to establish the elements of defendant's knowledge of the existence of the subject criminal enterprise and the nature of its affairs or his intent to participate in such affairs. Penal Law Section 460.20(1)(a). On the mens rea element, the people were required to prove, beyond a reasonable doubt, that defendant, having knowledge of the existence of a criminal enterprise and the nature of its activities, and, being employed by or associated with such enterprise, intentionally conduct ed or participate d in the affairs of an enterprise. Penal Law Section 460.20(1)(a). Consistent with this statutory mens rea requirement, the trial court additionally instructed the jury, without objection, that the people were required to show that defendant had chosen to be part of the group and to have worked as a member of it or in affiliation with it to achieve its criminal purposes. Here, the evidence of defendant's knowledge of the existence of the criminal enterprise and his intention to participate in its affairs fell short as a matter of law. The evidence of defendant's participation in the three requisite criminal acts included in the pattern activity alone does not establish defendant's knowledge of the existence of the criminal enterprise and the nature of its activities. In addition, the critical trial testimony of the people's cooperating witness demonstrated that defendant was isolated from, rather than employed by or associated with, the enterprise, and that defendant acted independently on his own behalf, with the singular purpose of serving his own interests. In light of this determination, defendant's remaining contentions are academic. Order reversed and indictment dismissed. In a memorandum, Chief Judge DiFiore and Judges Stein, Fahy, Garcia, Wilson and Feynman concur. Judge Rivera concurs in result in an opinion.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.